Hey everyone, Anthony here. This video is called, I guess, prerequisites to my court hearing. I want to give you guys kind of a brief introduction in like the motions that I just sent in yesterday, and like a prerequisite to the actual court hearing because I'm going to be uploading the court hearing to YouTube. So I just want to make a video giving you guys a briefer about some of the stuff that I'm going to be bringing up in the hearing. So also I apologize if you can hear like a little bit of noise or whatever. I'm making English muffins. It's 10:15 in the morning on Friday the 23rd. Let's just get into it. Let's just talk about, sorry about that, the motions that I sent in. So the first motion that I sent in is just a motion to withdraw my previous motions because I sent in 3 previous motions, either 2 or 3, I forget, back in March. No, not March, back in January. So 6 months ago, I sent in 3 motions. These motions were never heard, never even like mentioned in the previous court hearings that I had and whatnot. So the reason that I'm asking, I'll just read so I sent in a motion to withdraw my previous motions, and what I wrote in it, laptop's a little bit far away from me, so I have to zoom in. So I wrote, I am requesting that all my previously submitted motions from January 2021 be withdrawn and supplanted with new motions I have sent in. These new motions request the same things as the old motions and utilize similar arguments, however, are better worded and better reflect my current thoughts and depth of the trial. My previously submitted motions were sent 6 months ago and were never heard or decided on. So that last sentence is just to let them know, like, hey, you can withdraw these motions because they were never heard or decided on. So there's kind of no reason not to withdraw them. But the ones that I sent in was a motion to dismiss. I reworded it to motion to dismiss without prejudice and reworded some other stuff. Without prejudice means that motion to dismiss with prejudice, meaning that they can't open up this case again or whatever. So I sent in a motion to dismiss, a motion to suppress my previous court records, which I guess I'll argue that now, but I think maybe it's a requirement that you have to send in previous criminal history on new trials. I don't think that that's fair because it introduces like a poisoning of the well aspect that puts, like, if you see someone with a bad criminal history or record or whatever, you automatically assume that they're a bad person. It's called poisoning the well, and it's not an argument, and ends up giving unfair or bad outcomes to people because like jurors and judges sometimes will see that it's not evidence at all that this new crime was committed. It's like being on trial for murdering someone and the prosecution bringing up, well, you murdered someone 10 years ago, so you definitely murdered this person now. It's not evidence. So I sent in a previous motion requesting that be suppressed because I didn't want to poison the well of the jury by seeing my previous criminal record. Not even that it's bad, it's some stuff that happened 12 years ago, 10 years ago, and stuff that I didn't even do. And it's all like complicated stuff that you have to go into detail to explain and whatever. It's not really, doesn't really matter right now. So then the next motion that I sent in, so motion to dismiss with prejudice. So I wrote, hello and hope you're well. I am asking for this to be dismissed on the grounds that it has not met requirements to proceed past preliminary hearing due to lack of evidence. I'm attaching a copy of the hearing transcript, of the preliminary hearing transcript with this motion. All that the prosecution has established at the preliminary hearing is that I filled out a form to purchase a gun at Roll Call. Roll Call is the name of the place. I am not being charged with filling out a form. I am specifically being charged with lying on the gun purchase form. As per testimony given at the preliminary hearing, the prosecution has not presented any evidence that I lied on the gun purchase form. Evidence to show that I knowingly provided a false statement with the intent to deceive. Roll Call. nor have they ever spoken with me before or after filing the charges to even hear what happened and what I knew at the time of the attempted purchase or the events preceding it. I was charged and forced through these criminal proceedings without any evidence to distinguish if I actually lied or made an honest mistake. And for you guys, I guess, to get caught up, if anyone's watching this that's new, I went to purchase a gun in March of 2020, I believe. Back in 2009, I was involuntarily committed to a psych ward, which is kind of like a bad name for it or whatever. And at the time of purchase, I had no recollection of this happening. And I always I don't know how to get you guys to believe me on that or whatever, but that's just what it is. So it's absolutely preposterous to me that this has gone this as far as it is, because I would never take someone to court without evidence, and I wouldn't expect to be believed without it. It's like someone scratching your car at the grocery store, then taking the owner of the car parked next to you to court to pay for damages, despite having zero evidence that they are the person who scratched your car. No witnesses, no surveillance video, no matching paint transfer between cars, nothing. It's a waste of everyone's time to do so and completely unfair to the accused. And in my situation specifically has led me to lose faith in the district attorney and Scranton police. If the prosecution had witnesses to testify that I knew I was involuntarily committed, had presented a lie detector test or some other form of evidence that establishes that I knowingly provided a false statement, I could see this proceeding. But the fact of the matter is that the prosecution's case is based entirely on a completely fabricated allegation based on zero evidence and made with zero investigation into the events that occurred. So yeah, before charges were in order to determine someone's lying, you have to it takes a lot of work. Think about poker players. You have to sit there and read a person and really understand if a person's lying, and you have to test your theories if that tell is them lying or not. So say you're playing poker and you think a guy is bluffing. You think every time the guy touches his mustache that he's lying. Well, then over time you test that theory. Well, he touched his mustache this hand and it was a lie, but then the next hand he touched his mustache and he wasn't bluffing. He actually had a real hand. So maybe that tell isn't an actual tell. And also, like I said, with lie detector tests, I was never contacted once by Detective Spinozzi before pressing charges or anything. I don't know how you determine someone's lying without ever talking to someone beforehand. And as far as witnesses, there's no witnesses. There's literally no one in the world can say that I knew that I was involuntarily committed, because no one that I know, it's never came up in conversation or anything like that. So they don't have any witnesses for that. They're not saying that they do or anything like that or whatever. But that was just an example that I used. But yeah, it would be completely. Let me check on these English muffins. Just a little bit darker than I like, and you're not going to focus on that, but it's okay. Butter break. So the only reason that I believe that this was so with the preliminary hearing is when in a preliminary hearing, it's the prosecution or the plaintiff has to provide the judge that there's enough to charge, enough to proceed with the case. So the reason that I think that it went past the preliminary hearing without, the reason that I believe it went past the preliminary hearing is because I kept being argued with and yelled at and pressured into accepting a public defender, and they wouldn't proceed with any of these court hearings unless at a public defender. They kept putting into continuance and saying that I was mentally incompetent and all this stuff, blah, blah, blah. So I finally accepted a public defender for that hearing so we can proceed, and I wasn't allowed to speak at all during this hearing or anything. And then the public defender says that everything's based on hearsay. And no, it's not hearsay. That's not what hearsay is. Like, there definitely is, like, he was saying that so during the preliminary hearing, they brought in the guy from roll call, that the not cashier, clerk, or whatever, the salesman, the person behind the counter, they brought in, the prosecution brought in. I'm sorry, my mind's getting like all out of whack or whatever and making this hard to follow. But the prosecution brought in the guy, the salesperson or whatever at roll call, and interviewed him. And all that testimony established is that I went there to purchase a gun and filled out the form. It doesn't establish that I lied on the form. And the public defender was like, yeah, his testimony is based entirely on hearsay. No, like, that stuff actually happened, and I'm not denying that I went there to purchase a gun and everything. So the next one, motion to waive a jury trial. And I'm asking for a bench trial because, so a bench trial is just a trial with the judge, where the judge hears the a case and everything. There's no jury involved. And the reason that I'm asking for that is it makes everything way more complicated to have a jury trial, because then you have to select the jury and poll the jury and all that stuff. I really don't want to go through that. So I wrote, so far, judge, I'm not going to put his name in this video, has acted fair and unbiased, has let me speak and listened, and has made decisions which I believe to be correct. So when the prosecution tried saying that I'm mentally incompetent to stand trial and say that I'm mentally incompetent to defend myself, which is crazy, because you always hear people saying like, you always hear people saying like, the prosecution is like, oh, this guy's not mentally incompetent, this guy can stand trial, and like they always take the other side of the argument. But now they're trying to say that I am mentally incompetent, or they were. I got that dismissed and won that hearing. So that's what I was referencing when I said he's made decisions which I believe to be correct. So I see no need for a jury, no need to take time away from the lives of jury members, cost the Scranton taxpayers more money, they're taxed high enough, one of the reasons why I left, or make this more difficult on all of us involved. Therefore, I'm requesting a bench trial with Judge. This does, however, bring up the issue of the prosecution poisoning the well, which I would like to discuss alongside this motion, but I don't foresee it changing my decision in a bench trial. Waiving a jury trial also means my motion to suppress previous convictions no longer needs to be heard, as it render irrelevant. So what I mean with that, when I say like prosecution poisoning the well, that's with previous criminal records being brought into the case, because like I explained earlier, that poisons the well. I don't see that being an issue with the judge, because I think judge would understand that that's not evidence. I have to talk to him about that though anyway, but motion to suppress kind of makes it, to suppress previous criminal records makes that irrelevant if I'm asking for a bench trial, because the judge is going to see all that to make the decision anyway. If I ask for a motion to suppress previous criminal records, and the judge needs to see those previous criminal records to suppress them, well, the well is already poisoned by him seeing this stuff. So next, subpoena for body cam footage. Let me eat some of this breakfast. So a subpoena for body cam footage. On or about March 11th, 2020, this event happened a day or two after I attempted to purchase a firearm. Police records confirm the date. Detective McLean and another officer were called to my house to investigate a call I made about Chad. I'm not going to put the last name in there. Vandalizing my vehicle, rummaging through my mailbox, and trying to break into my apartment. During our conversation, the officer made me aware that his body cam was recording. Later in the conversation, 30 minutes to 1 hour later, I brought up to Detective McLean that I recently attempted to purchase a firearm and was denied. We spent probably 30 minutes trying to figure out why it was denied and why, and I was asking him what course of action to take next to figure out what happened. The recording of this conversation will be definitive proof that I did not know I was involuntarily committed. It will demonstrate my honesty and openness during our conversation and genuine unknowingness of a involuntary commitment. During another visit by Detective McLean to my apartment in winter 2021, I forget the exact date, I have it on my security footage. Detective McLean confirmed that the body cam exists and he watched it. I've made 3 attempts for the body cam footage and was denied each time. One request was made to the Scranton Police Department. Another 2 requests were made to District Attorney. I'm requesting Judge compel the release of this body cam footage as evidence in this hearing. Motion to drop felony charge. I am being charged with 3 counts, 2 misdemeanors and 1 felony. The felony was used in bad faith to threaten me into pleading guilty and added after I refused to do so. I can prove this with testimony from Detective Spinozzi. However, that is not the argument I'm trying to make in this motion. The point I'm making in this motion is that it does not relate to any event that took place. There are only 2 issues of contention in this case. The answers I provided on ATF form 4473 and form SPF 4-113. Both questions asking if I was ever involuntarily committed before. Therefore, at most, I should be charged with 2 counts. However, I am being charged with 3. I believe this constitutes double jeopardy as per the Blockberger test. So that's United States versus Blockberger versus United States. As there are no additional elements in the felony charge that are not already covered by the misdemeanor charge. Being charged more than 1 punishment for the same offense is simply unfair. So there's an established test already on double jeopardy, which basically says that in order for a new charge to be added, it has to have a new element. There has to be a new element to that charge for the crime. So, let's just take 2, for example. Burglary and murder, these are just 2 far apart examples, but used for demonstration purposes. We can take burglary and murder. There's 2, or stealing and murder. There's 2 different elements to that crime. Murder, the act of killing someone, and stealing, the act of stealing from someone. So that's just the basic test. There has to be an additional element in the new charge or whatever. I always get want to give up in the middle of videos because I get lost on where I am and what I recorded and everything. So the other thing I wanted to say, so they appointed standby counsel to me, which I already have standby counsel. I have a lawyer that I speak to, my own private lawyer, about this anyway. So I started emailing standby counsel last month, asking him for guidance on the court procedure, to see if I needed to send in all my evidence now and whatnot or whatever. And I was asking him a list of an order of events that take place, because there's the Scranton or Pennsylvania criminal or rules of criminal proceeding and rules of evidence. But the rules of criminal proceeding lists out everything. So I was asking him about the order of everything and what to expect in my next hearing, which is a pretrial conference. And he just said, it's up to the judge's discretion. And I'm like, well, you're not really giving me good advice. If you're appointed as standby counsel, and I just had another train of thought for something else that I wanted to say. If you're appointed as standby counsel in order to make sure that the court proceeding goes smoothly, and one, that I'm not bothering the judge and his office with all my questions and everything, saying that everything's up to the judge's discretion doesn't really help me there. it's kind of useless. It doesn't help anyone, because now the only way to resolve my questions are to ask the judge. And if everything's at the judge's discretion, I have no idea what's going on or anything like that, or how to proceed or how to prepare for hearings. The other thing I wanted to mention is when he initially emailed me, he's like, I was looking over your case and there's no way you can win this. And I'm like, what the hell are you talking about? It's like extremely discouraging to, like, when I haven't submitted any of my arguments or evidence or anything like that, continually being told there's no way you can win this, no way you can win this, and whatever. I know that I didn't lie. Like, just makes me lose faith in everything. And that's why I don't live in Scranton anymore, and why I stay in my house. And but all right. Yeah, so the next video I'm going to upload, so today's Friday, Monday is my hearing. I think it's at 10 o'clock in the morning. I have to check. I'll be recording that hearing and uploading it after I upload this video, or releasing it. I'll upload it whenever, but I'll release it after this video gets released. Can you guys hear me?
Yes,
Yeah.
we can.
Okay.
Cheryl?
Yeah.
So Andrea shot me a text earlier and was wondering if Sean pled on 2 counts of possession.
I believe so. Let me just double check. I think he did. Yeah, 6 and 7.
Okay,
Okay?
thank you.
Mm-hmm.
Did you guys get my updated address from the post office?
I don't believe so, Mr.
Okay.
If you want to put it on the record when the court reporter logs in, she just texted me she was having trouble with the link.
Okay.
There she is, Judge. Christina, do you want to call a case for Mr.
Yes, Your Honor, this is Commonwealth versus Anthony 20 Criminal 2061. This is the place and time set for our final pretrial conference.
Okay. Mrs. So what's your intention with the case?
To plead not guilty?
Okay. Trial is scheduled for September 13th at 9 a.m.
Okay.
Your
Thank
Honor,
you. Yes.
Mr. Bozo previously indicated when we were on screen that he may be willing to proceed to a bench trial. I don't know if that would still be his desire, but...
Yes, I would like one. I sent in a motion on Thursday for one.
Okay. Well, I don't have that as of yet. Once we get it, we will make a determination, okay?
Okay, yeah, I sent in a bunch of different motions. One of them yesterday and a bunch more on Thursday.
All right, we'll take a look at it. Thank you.
Okay, is that it? Can we just have 1 second? So I wrote out like 29 pages. Can I just look over my notes to see if there's anything to discuss
One
while
question for you is, would you want to put your address on the record, please?
Yeah, it's, do you want to see a copy of my new driver's license with that address too, or I could
No,
email
that's
it
not-
to you.
That's not necessary. Thank you.
Okay.
Yes, thank you.
Thank you, Your Honor.
You want to call next case?
Judge, it's
Mm-hmm.